Hello, I'm Bert Smith. Let's continue exploring Chancellor James Kent of the New York courts. Given the focus of this topic, I think this presentation would be ideal for a local bar association meeting or perhaps a college seminar on legal history. In terms of the search parameters for this video, the Oxford Academic Database yielded many of the articles that were in the JSTOR database. With regard to the Project Muse database, there were really no articles directly for Kent. However, there were articles that cited him or his works. In the Project Muse database, I found an article titled Blasphemy and the Law of Religious Liberty in 19th Century America by Sarah Barringer Gordon. Gordon begins the article by citing Kent's 1811 decision, People versus Ruggles. Ruggles was convicted of blasphemy for shouting that Jesus Christ was a, quote, bastard, unquote, child, amongst other obscenities, which conviction was upheld by Kent. Gordon looks at the development of religious freedom cases concerning morality codes and their transition from state to federal jurisdiction. Notably, Mormon polygamy was cited as an example of a marriage descent from normal standards, which presented a Christian-based or quasi-internal threat to morality codes. Gordon concluded that, quote, the hardening of moral lines of constitutional jurisprudence translated the prescriptive nature of general Christianity from a basic fact of American legal culture before the Civil War into a constitutional code by 1890, and that's at page 709. In Curia Adversari Vult, Kate Elizabeth Brown addressed the early jurisprudence of New York's Court for the Correction of Errors, which was a unique incorporation into the state constitution of an appellate court based upon the House of Lords concept. At the beginning of the article, she notes that many early jurists came from New York, including James Kent's commentaries on American law, that she describes as the answer to Blackstone's authoritative synthesis of the laws of England, and that's at page 94. Brown highlights that the unique provisions of the Court for the Correction of Errors was review of the Chancery Court and the New York Supreme Court, rather than simply legislative initiatives as was done in most other states. That's at page 97. The results from the Oxford Academic Database included an article about the Federalist Papers. In Settling the Authorship of the Federalist, Irving Brandt explores a list of Federalist Papers and their authors, and which were contained in a flyleaf of Chancellor Kent's copy of them. Brandt concludes, quote, since no one doubts that the same person wrote numbers 62 and 63, the Kent list appears to wipe out the last uncertainty about the authorship of the Federalist Papers. And that's at page 75. A final source, or even set of resources that I found, were several book reviews of James Kent, A Study in Conservatism, 1763 to 1847, which is the only biographical work on Kent written by John Theodore Horton in 1939. For example, J.L. Sellers wrote that James Kent enjoys the greatest national reputation of any American jurist who has not occupied a national office. That's at page 101. Francis G. Wilson, in his review of the book, noted that it did not deal in sufficient detail with legal doctrine nor show the legal influence of Kent. Quote, but it must be said that the book is not for lawyers, but for historians and students of politics. It is an enlightening document for the study of American political theory, and that's at page 119. Finally, Richard B. Morris stated in his review of the book that Horton illustrates Kent's respect for property rights, invoking principles from the English Chancery, yet highlighting Kent's defense of deviations in American law from those English foundations, and that's at page 907 and 8. Kent's contributions to American jurisprudence were noteworthy. His contributions to law and politics have been influential and long-standing. Thank you for watching.